Hello, everyone. This is Tom Fox. I'm the Compliance Evangelist, and I'd like to welcome you to episode 381 of the FCPA Compliance Report. Today, I have back with me James Koukios. James is a partner in Morrison and Foerster in Washington, D.C., and he's the former assistant head of the FCPA unit in the fraud section at the Department of Justice. He joins the podcast again to talk about some of the key developments in international anti-corruption over the past couple of months, specifically in January and February. Some of our topics are the PDVSA indictments, the Petrobras shareholder derivative action, two other FCPA-related shareholder derivative actions which invoked RICO, the implications from the Digital Realty Trust case from James's former DOJ perspective. We take a look at some of the tide-changing laws that have been implemented in South America around anti-bribery, anti-corruption, and we take a look at some of the declinations in the January and February timeframe and ask, do they communicate anything to the compliance practitioner? As always, when James Koukios joins the podcast, it's a fascinating exploration, taking a deep dive into several very interesting compliance and FCPA topics. The FCPA Compliance Report is a part of the Compliance Podcast Network. Hello, everyone. This is Tom Fox, back for another episode, and today I'm extraordinarily pleased to have back with me my fellow Wolverine and NCAA championship game attendee, James Koukios. James, welcome.
Thanks, Tom. Go Blue. It was a great run. We came up a little bit short, but the Wolverines did us proud.
That they did. Well, James, we've been saving up for a couple of months here, and there's quite a lot to talk about in the top 10 from Morrison and Foerster in the newsletter, so perhaps we could jump right into it. I was particularly interested in the Venezuelan bribery case, whether you call that PDVSA, the individual defendants, and I really wanted to maybe look at it from this angle, James. Obviously, the FCPA, as a supply-side law, criminalizes the bribe payer. But for every bribe payer, there has to be a bribe receiver. And then if it's anything over $10, that money has to be put somewhere. So meaning it has to be laundered. And I really thought the individuals, Cesar Rason particularly, demonstrated that second part of global corruption, which is the bribe receiver and how they laundered the money, and then really how the Department of Justice used laws other than the FCPA to fight this global scourge. And I was wondering if you just might be able to talk about that part of the fight against corruption.
Sure. No, you're absolutely right, Tom. There oftentimes in FCPA cases, you'll see money laundering charges against the bribe payer as well, because oftentimes the bribe payer is using shell companies offshore, things like that, to conceal and transmit the money out of the United States. But as you said, the Supreme Court has held that you can't, not the Supreme Court, but the appellate courts have held that you can't bring FCPA cases against officials. And the reason often posited for that is that's a foreign policy issue that shouldn't be decided by the courts. I think there's a lot of wisdom to that. I mean, we didn't like it when Nigeria indicted Vice President Cheney, and you could see where it could be a very sensitive issue if prosecutors went around indicting foreign officials all the time for FCPA allegations. That said, DOJ has made it clear for quite a while that there are going to be cases where the money laundering activities from the bribery so affect U.S. commerce that they're going to use the anti-money laundering laws to bring cases against officials. I was involved in some of those cases. For example, U.S. v. Duperval, which is a Haitian official who was charged with accepting bribe money from some Miami telecom companies and laundering the proceeds through shell companies and bank accounts located in South Florida. And the decision was made in that case that this affects the U.S. enough, and also in that case, the Haitian government was behind it, that we brought that case, and a couple other ones I was involved in as well. But I think recently there's been a lot of push from the business community to try to attack bribery, foreign bribery, from both the supply side and the demand side. And it does seem that that message has been getting through to DOJ, and they've been beginning to bring, I think even more frequently, cases against officials on the demand side for using the money laundering statutes. So far, that hasn't been challenged in court. There's an argument to be made that is an end run around some of the appellate court decisions that say you can't charge an official directly for an FCPA violation, and this is a way to get around it improperly. They haven't raised to the level of appellate courts yet, but one interesting thing will be to see is if DOJ does continue to use the anti-money laundering statutes to charge officials, will there be another FCPA case, appellate court case, addressing this particular charging theory, which I think is going to be pretty interesting. I think in the meantime, the business community is pretty happy about this because, again, it's not just focusing on them on the supply side, but also going after and trying to deter the demand side as well.
So in the PDVSA cases, though, James, we had U.S. Jurisdiction because we had money actually routed through U.S. banks by an individual who, although I do not believe was a U.S. citizen, at some point in time was in the United States to carry out part of the bribe scheme. So we had, the citus jurisdiction in the United States. Does that make a difference?
It does. It does. So that is one of the policy-based decisions that DOJ considers is how much of an impact did these transactions have on the U.S. banking system and the U.S. economy? And if the answer is very little, then there's going to be a much higher chance that they will not use their discretion to bring anti-money laundering charges. But if the more nexus there is, the more activity there is in the United States, the more impact there is on the U.S. banking and financial system, the more likely it is that DOJ will bring cases using the AML statutes against the foreign officials.
So I'm here in Houston. PDVSA is much more well known. They are obviously a major player in the international energy development space. Business-wise, Halliburton this week announced they had to write off their entire investment with PDVSA. Chevron just this week also won a $2 billion claim against PDVSA. So they're in the news a lot, and their corruption is in the news a lot. And this is also really tied to U.S. sanctions around Venezuela because PDVSA owns actually a U.S. refinery, Citgo. So many are wondering kind of what may happen along sanctions. And if there was one entity, issue, or case that I would say we are going to be watching for some time, it's certainly going to be PDVSA. Absolutely.
And I think this prosecution has a lot of legs, and there may be additional charges brought as well.
We will just continue to watch this space, as my English wife would say. James, we had a couple interesting FCPA-related RICO lawsuits, and these are becoming perhaps a little more increasingly common. They often take the form of shareholder derivative actions or securities fraud actions. What do you see are the implications for the compliance professional?
Well, it's interesting. You're right. For the most part, for a long time, what we saw was if there was some kind of public disclosure of potential FCPA violations by a publicly traded company, whether it be just a securities filing or an actual enforcement action, it would be followed by wave after wave of shareholder derivative suits and the like. It seems some of those have been successful, some not so successful. But it seems like plaintiffs' attorneys have decided that a new tack to pursue is the RICO lawsuit, and so it's not unprecedented. It's not that it's never happened before, but it was interesting that there were two new ones filed in earlier this year, and that may be an indication of things to come. That the civil RICO statute might be used more. And obviously that causes all kinds of problems downstream. For example, if a publicly traded company is cooperating with the U.S. government or other governments and is making presentations about investigative findings or the like, we've seen several cases recently that show that might lead to a claim of, for example, privilege waiver or attorney work product waiver, which could make it more difficult when civil plaintiffs bring these kind of cases.
So typically we see a shareholder suit filed when an FCPA investigation is announced, but it's not resolved until long after the regulatory settlement, either from the Department of Justice and or the Securities and Exchange Commission. From the DOJ or former DOJ perspective, is that almost like white noise to what you guys had to do, or was it ever considered as a part of the enforcement actions you guys were bringing?
It was really pretty separate from what we were doing. There were times where it could be a distraction. For example, if the plaintiffs tried to get certain discovery or things like that we thought might interfere with the criminal case, we might go and try to file a stay of the civil action. On the other hand, there are some times where it was possible that the civil suit might kick loose some information that we or otherwise might not have gotten as criminal prosecutors or not have thought of as criminal prosecutors. And so sometimes it actually worked in our benefit. So at one point, there was a reflexive action by DOJ that whenever a civil suit was filed, you'd automatically move to stay. But over the years, I think you saw the DOJ prosecutors becoming a little more nuanced, evaluating the circumstances and evaluating how the particular civil action could be detrimental or helpful to the case, and then decide how to go forward from there. It also seemed that judges were tending to be a little less inclined to grant stays. So I think that also DOJ had to be a little bit more circumspect in which cases they moved to stay.
Well, we're going to talk about one of the largest FCPA shareholder related settlements a little bit later. But typically what I see from the compliance practitioner perspective is really not much from the shareholders' action. I can only think of two shareholder actions where, as part of the settlement, there was something directly related to a compliance program, either an innovation or an additional component of a compliance program. Typically, it's just a payment of legal fees to the plaintiff's counsel. So it's going to be interesting to see if this new tactic, where that may take it.
Yes.
So we had one of the most significant whistleblower cases recently from the U.S. Supreme Court in the form of Digital Realty Trust versus Summers. There's been lots of discussions about what this may mean for regulators in the form of Securities and Exchange Commission, to corporate compliance programs, to individual whistleblowers, to those who represent whistleblowers. But I've been really interested in wanting to talk to you, James, to really see if I can get an understanding from the former DOJ perspective. What was the significance you saw in this case, and will it really make a change for what the Department of Justice does going forward?
Sure, thanks, Tom. So when my last couple of years as an assistant chief in the FCPA unit, I ran the whistleblower program for DOJ. So we had an email address where people could submit whistleblower complaints. And what I really saw after Dodd-Frank was the increased involvement of whistleblower attorneys, which did a couple things. Number one, it meant that the whistleblower complaints were much more sophisticated, fulsome, and helpful than they were when we were just getting emails from, pardon the term, but random citizens who just said, I think my company's paying bribes. The whistleblower attorneys knew how to package it a little more and make it more interesting and useful for us. It doesn't mean, though, that it increased necessarily the volume of the veracity of the complaints, because at the end of the day, if the whistleblower was making it up or if the whistleblower didn't have the full information, it still wasn't helpful. But it did give rise to this more whistleblower attorneys and I think more complaints filed with SEC and DOJ. I think the digital reality, if you look at it from that perspective, it's kind of a mixed blessing for companies. On the one hand, it says, we may be able to defend ourselves in a particular whistleblower suit because you didn't go to SEC or DOJ. But at the same time, if I'm a plaintiff's attorney, I have a client and the client's trying to decide, should I go to SEC or should I report this internally? I may say you better report this externally so that we can still have the ability to bring a retaliation claim later on in case things go wrong. And so I think from a DOJ perspective, I remember when the Asadi case came out and thinking like,
Right.
it was a short-term victory, but is it going to be a long-term loss or at least a long-term complication for companies? And so I think if you're a company dealing with this, I think you need to really, it may help you in a particular case, but you really need to go back to your whistleblower program and make sure that you have all the doors open and all the avenues open to get those whistleblowers to feel comfortable reporting internally and not to go with that external reporting. So you can hopefully, investigate and handle these things yourselves, because once it gets into the government's hands, you really lose control over the investigation. You sometimes lose control over the narrative. And I think it's really important to try to make sure to, in a very appropriate way, consistent with the SEC admonishments and the law, to say, look, we are a company that receives and takes seriously and investigates whistleblower allegations. So hopefully you can avoid this incentive from Digital Reality for plaintiffs' lawyers to tell you, hey, go report this to the government right away so that we can preserve these rights later on.
Yeah, I've gone so far as to say don't ask for something because you might get it, and that seems to me to be exactly could turn into a long-term loss or at least a complication, as you said, James.
Definitely.
We saw Canada is moving towards supporting or implementing DPAs, and really I wanted to use this, James, as maybe a starting point. I don't think, discussed any Canadian cases in this case. They're obviously a very close neighbor of us, but I was wondering kind of what's the rapport between Canadian prosecutors and American prosecutors, the cooperation, or did you have the opportunity to meet with them and talk through and kind of get their views, or how, I guess, can I get a sense of really how that works at the prosecutorial level?
Yeah, we actually had very good cooperation with Canada from the law enforcement side, just like we do, I think, in most areas of being neighbors. I'm from Michigan, of course, so we always kind of considered Canada just to be another state, not in an offensive way, but you'd always say, have you ever been out of the country? No. Well, I've been to Canada. Right. That's reflective of the closeness that we had between our two countries and the ability to cross borders. But we did have a good enforcement relationship with them. For example, I don't know if you remember the Carragher case, which was the first case that the Canadians actually convicted an individual of foreign bribery. If you read the decision, it references the cooperation that DOJ provided in that case, including, in fact, the whistleblower note. Carragher actually self-reported himself via the DOJ whistleblower email address, said that he was paying bribes on behalf of a company, and somehow seemed to think that was going to give him negotiating leverage with the company he was paying bribes for. It didn't work out very well, and we provided that information to the Canadians, and that was some of the evidence they used to convict him of that. So there was a very good relationship there. They're also obviously a member of the OECD, and so they're at the working group meetings, and they're subject to peer review and things like that. And really, I think the DPA is emphasized as a useful enforcement tool for OECD members. The OECD really looks a lot to the success that the U.S. FCPA enforcement has had, and looks to reasons for that success, and seems to think that one of the reasons for that is that the DPA offers a flexible enforcement tool. And so I think it's not a surprise that several OECD members, not just Canada, but Australia, France, the UK, are also considering or have adopted DPA regimes as well as a useful enforcement tool for foreign bribery prosecutions. They can be used to incentivize self-reporting and cooperation, and they can be a little more flexible than some of the more rigid legal systems out there, where it can be very difficult to plead guilty or convict a company of foreign bribery. So I think this is a trend that we're seeing across a lot of the OECD member nations of starting to adopt that sort of American-style DPA. Although with a twist, Canada's not adopted it yet. but it seems like it may be leaning towards it, but leaning towards more of a UK regime that requires court approval and mandatory publication of DPAs, whereas in the United States, DOJ has fought against needing court approval and does typically publish the DPAs publicly, but is not required to do so.
So we foreshadowed this next topic a little bit, but we had a huge shareholder settlement on an FCPA-related matter, which was the Petrobras shareholder settlement. This was a $2.95 billion settlement. It was not an FCPA settlement. It was a settlement for the devaluation of the stock price based upon allegations of bribery and corruption that the plaintiffs' counsel alleged the board of directors were aware of or did not take appropriate steps. So it was very interesting. It was in front of Judge Rakoff. It was, as I said, the largest case. The next largest case on an FCPA-related shareholder case was $77 million. So it shows you really the size of this case. And I'd been wanting to visit with you, James, to get your thoughts. Is this case really a complete outlier, or could it be a harbinger? When I say outlier, I mean really based on a very unique set of facts?
I do think there's a lot of uniqueness to this. I mean, involves a lot of money, obviously, because it's a major oil company over a long period of time, where there's been a tremendous amount of investigative work put in by several different countries, law enforcement agencies, to look into this. So it is a bit of a unique situation. I think one really unique situation is that the Brazilian government and prosecutors tended to see Petrobras as a victim of the bribery, that the allegedly corrupt officials and executives of Petrobras actually victimized the company. So it's very interesting that eventually Petrobras did agree to this settlement. Probably, I mean, I'm speculating now, but there was a lot of money at issue here, and it may have just made sense to try to stem the losses by doing this, even though it's still a record-setting resolution. But I do think there's going to continue to be shareholder suits. We talked about the RICO suits. But I do think that the Petrobras situation is fairly unique, given everything else that's been going on in Brazil and elsewhere regarding Petrobras.
And I probably should have said this at the introduction of this topic, James, but this was not Petrobras, the Brazilian company. This was Petrobras USA, a U.S. stock exchange listed company where there was a demonstrable drop in stock prices. So often in FCPA-related shareholder actions, there may be some drop, but you don't have a truly dramatic drop. And even if you do have some drop, excuse me, the price picks up later, which did not happen for Petrobras USA. So, as I said, a really unique set of circumstances. So it may be just limited to the facts, but now we have a precedent. And as we all know, once you have one precedent, others find their way along. So this is going to be an interesting one to watch.
Fair point. Very complicated and interesting resolution.
So we have seen over the past 18 months, in addition to Petrobras, the Brazilian prosecutions, new laws from other South American countries, and really a new awareness about the global fight of corruption. And Peru introduced a new anti-bribery, anti-corruption law. And I was just wondering, from your perspective, James, have you seen this change and at the prosecutorial level in South America? And is that something that you really think is changed things?
Yeah, so this is, again, OECD related, where Peru wants to become a member of the OECD. And one of the requirements of the anti-corruption, anti-bribery convention is that you have, if not criminal liability for corporations, at least a liability regime for corporations that will make foreign bribery be deterred by the liability. So I do think we saw with Brazil, which is obviously an OECD anti-bribery convention member, which introduced their corporate liability law. And I think the more that South American countries and others want to integrate themselves into that, the OECD member nations, they're going to start moving towards corporate liability for certain offenses.
Well, it's going to be, I find it fascinating. And actually, I'm presenting with a couple of guys at SCCE in October on this subject. So with Peru, and I said Argentina, I think there's some renewed emphasis now in Mexico. It's going to be very interesting to see more prosecutions, perhaps in countries in South America other than Brazil. James, we had a series of declinations really beginning back in January. We had a big one for Houston and the Houston energy community with Cobalt International, but we've had a few other declinations. I will leave Dun & Bradstreet for a later day since that did not happen in January or February. But we had Jupiter Networks, we had Teradata and Xterra, and another Houston-based company. And I was just wondering if you guys saw anything in any of these declinations that would communicate information to the compliance professional.
Sure. I think it's very interesting to read about these declinations in the context of the FCPA and pilot program and the enforcement policy. Given now that DOJ tends to not decline a lot of these cases without at least trying to get disgorgement. So we see that some of these cases where DOJ declined, the companies noted in their securities filings that the SEC is still continuing to investigate. And so what that might mean, and we don't know for sure, but what it might mean is that DOJ has decided, this is not a case for us. There is an administrative penalty available that might be more appropriate. So we're going to take a pass on this one and let the SEC enforce it. Whereas if they were not publicly traded companies and there wasn't the SEC action, we might see a declination with disgorgement or some kind of action going forward. So I think one of the most interesting things is before the pilot program and before the corporate enforcement policy, people would always say, well, we don't know why you're declining. And given the current state, a declination seems to indicate either for these ones with the SEC that there may be a policy reason to decline because there's another administrative action agency that can go forward with that. Whereas if it's a straight declination, it may suggest instead that there was no evidence, no jurisdiction, the statute of limitations had expired, things like that, where DOJ actually felt it couldn't bring the case and was not making a policy-based decision, but instead a strength of the evidence type determination.
So I think lots of people here, certainly in the Houston compliance community, looked at both the work done by Cobalt and Xterra on their compliance programs and really took away that from the remediation perspective, the more remediation you can do before, obviously you self-disclose, but even after self-disclosure during the pendency of an investigation, it's going to help you to get a better result, whatever that better result might be at the end of the day. So that was one of the takeaways we had down here.
I think that's fair. And I think DOJ has done a lot of, for the last couple of years, really emphasized self-disclosure, cooperation, and remediation as ways that that can mitigate FCPA, otherwise potentially very serious FCPA problems. So I think that's a fair takeaway.
Well, James, as always, this has been a fascinating exploration of the Morrison and Foerster top 10 international anti-corporate developments. We took a look at 2 months this year, on this podcast, January and February, and I greatly look forward to finding out what you guys want to talk about in March and April.
Thanks, Tom. Go Blue.
Go Blue.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance Report. If you have listened to this podcast on iTunes, I would greatly appreciate it if you would rate our podcast, as it would help in our rankings and help get the word out about the longest-running podcast in compliance. Also, if you have any questions, you can email me at tfox@tfoxlaw.com. Thank you again for listening to this week's episode, and I hope you will join us again next week when we present another episode of the FCPA Compliance Report. The FCPA Compliance Report is a part of the Compliance Podcast Network.